Welcome back to AI DIY. As you can see, I'm not Matt. I'm Scott from the Sunday Live Show. I'm the ex-industry guy, and while Matt is away, Scott will play and hopefully not mess anything up. There have been some stories circulating on the interwebs about the Supreme Court not hearing an AI copyright case, and I wanted to take a shot at explaining this. So today, I wanted to discuss this quiet legal non-decision that is being promoted as having massive implications for AI, creativity, and business. Earlier this month, the U.S. Supreme Court declined to hear a case that asked a simple but explosive question. Can artificial intelligence be considered the author of a copyrighted work? The short answer, for now, is no. But the long answer is where things get interesting. Let's start with the facts, because this story has been widely misunderstood. A computer scientist named Stephen Thaler created an AI system called DABUS, or the Creativity Machine. That system generated an image titled A Recent Entrance to Paradise. Thaler applied for copyright, but listed the AI as the sole author. The U.S. Copyright Office rejected it, federal courts rejected it, and finally, he appealed to the Supreme Court. On March 2, 2026, the Supreme Court refused to hear the case. Now here's the key point many articles blur. The court did not rule on AI copyright. It simply declined to review the case, leaving lower court rulings in place. Because the Supreme Court didn't intervene, the existing legal framework stands. Copyright requires human authorship. This principle has been reaffirmed repeatedly. The Copyright Office says it will reject works without a human creator. Federal courts call human authorship a bedrock requirement. So as of today, AI alone cannot own copyright. Fully autonomous AI-generated works are not protected. However, and this is critical, AI-assisted works can be copyrighted if a human contributes creatively. Some coverage frames this as a dramatic Supreme Court ruling against AI. That's not quite accurate. Here's the reality. The court did not decide whether AI can be an author. It did not create new law. It did not settle the issue permanently. Instead, it avoided the issue entirely. And that distinction matters. Because a denial of review sets no new precedent, leaves room for future cases, and often signals the court is waiting for a better test case. Another key nuance. Thaler's case was actually extreme. He argued, the AI created the work independently. No human contributed creatively. That's very different from how most AI is used today. In real-world scenarios, artists use prompts, designers edit outputs, musicians refine AI-generated material. And under current guidance, those human-in-the-loop works may still qualify for copyright. So this case doesn't shut down AI creativity, it just draws a line. No human equals no copyright. Now let's talk about what this means going forward. Businesses face a risk. Companies using fully automated AI pipelines may produce content they can't legally protect. That's a big deal for marketing assets, media production, software-generated content. Creators are still safe, for now. If you're using AI as a tool, you can likely still claim copyright, but you must show human creative input. Expect more scrutiny on prompts, editing, creative control. Legal uncertainty remains. This issue is far from settled. The Supreme Court could take a future case, or Congress could rewrite copyright law entirely. And many experts believe current law is outdated for AI-era creativity. The real question is still unanswered. At its core, this case raises something deeper. What does it mean to be an author? Is it the human who wrote the prompt, the engineer who built the model, the company that trained it, or the machine itself? Right now, the law gives a simple answer. Only humans qualify. But that answer is under pressure. Here's the clean takeaway. The Supreme Court did not rule on AI copyright, but it allowed existing rulings to stand, which means AI cannot be an author under current US law. Human involvement is still required. And most importantly, this is not the final word. It's just the current checkpoint.